Hello everybody, my name is Alice Ann and I work as an associate at Zeiler.Partners in Vienna in Austria. Today I would like to give you a brief introduction on the topic, the applicable law in international arbitration. Determining the applicable law in international arbitration can be a highly complex issue, yet in theory it sounds quite simple. In principle, the parties may agree on the applicable law. The parties may agree on the law applicable to the arbitration agreement, to the arbitration proceedings, and to the merits of the dispute. Further, the parties may also agree on the conflict of law rules applicable to determine each of the laws I just mentioned. If the arbitral tribunal fails to respect the parties' choice of law, it risks that the arbitral award could be set aside. For instance, according to Article 34, Section 2, Litera A, Subsection 2 of the UNCITRAL Model Law, or that the arbitral award could be refused enforcement according to Article 5, Section 1, Litera D of the New York Convention. The importance of the parties' choice of law is acknowledged in the New York Convention, that is in Article 5, Section 1, Litera A and Litera D of the New York Convention, regarding the law governing the validity of the arbitration agreement and the law governing the arbitration proceedings. However, as to the applicable law in absence of a parties' agreement, the New York Convention remains silent. The methods to determine the applicable law absent a parties' choice of law can be divided into two categories. The so-called direct approach, voie directe, allows the arbitral tribunal to apply the substantive law it deems applicable, whereas the indirect approach, voie indirecte, directs the arbitral tribunal to use a conflict of law analysis to determine the applicable law. Both approaches have been adopted by arbitral institutions and also in domestic arbitration. That means that if the parties fail to agree on the applicable law, it remains unclear which law will apply. Arbitral tribunal will follow different approaches depending on the case at hand. Several laws may be relevant, also in combination, be it the law at the seat of the arbitration, the so-called lex loci arbitri, the law applicable to the contract, the so-called lex causae, and, if known, the law of the enforcement state. On top of this, arbitral tribunals must also apply the mandatory provisions of national laws from which the parties cannot deviate. In essence, arbitral tribunals must apply the law chosen by the parties. If the parties fail to do so, as it is quite often the case in legal practice, arbitral tribunal must choose the applicable law depending on the facts of the case at hand, by dividing the dispute into single elements, by using criteria such as selecting the law with the closest connection to the dispute or to the single elements of the dispute. Definitely not an easy task. The wording as often used in arbitration rules, for example, in Article 27, Section 2 of the Vienna Rules, that the arbitral tribunal may apply the law it deems appropriate absent a parties' agreement, sounds clear and simple, but this power has to be exercised with greatest caution, otherwise there will be a great risk that the arbitral award could be set aside or refused enforcement. Thank you very much.